We've discussed how a federal judge in New York came out and said that almost all of New York's new gun control laws are unconstitutional under the Second Amendment, and yet he dismissed that case and did not officially make that decision because he said the plaintiffs that brought it lacked standing. And therefore, even though he thought that the New York laws were unconstitutional, there was nothing he could do about it because the case that was brought did not establish that he had jurisdiction over it because of an alleged lack of standing by the plaintiffs. Now, although I think that was wrongly decided on the question of standing, I want to talk about why I think this is ultimately a great ruling for the Second Amendment, and it will pay dividends down the road because there's many historical examples of this in the exact same context of our right to keep and bear arms. And I want to discuss one of them in just a second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, best-selling author, constitutional attorney, member of the United States Supreme Court Bar, and most importantly, that's right, proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And feel free to follow me on Twitter. Sometimes I get information out faster on Twitter than here, but check it out as well. Okay. We've talked about over the last several days the decision in the Handbook case against the state of New York involving the new gun control laws and how the federal judge in that case in the Northern District of New York said that almost all the new gun control laws by New York are unconstitutional under the Second Amendment, which they almost certainly are, by the way. We also talked about how, unfortunately, that in that case, the judge decided that the plaintiffs lacked standing, which is a prerequisite for a federal court to have jurisdiction over a case, meaning that the plaintiffs that brought the case have standing and are allowed legally to be in that court arguing what they're arguing, and the court said they did not do so. Now, although I think that's probably the wrong decision on standing, that's not the point of this video. The point of this video is to really give you another critical example where a decision that was lost by the plaintiffs in the Second Amendment context was still a major win for the Second Amendment and set a precedent for future victories for gun owners all across America. That was a case called Emerson versus the United States. The Emerson case is very important for you to know about. Why? Because the Emerson case by the Fifth Circuit Court of Appeals in Texas in 2001 was the first federal court to state that the Second Amendment clearly protects an individual right to keep and bear arms, and that any modern liberal theories associated with collective rights or militia rights has no basis in the law. And those theories of the modern left were rejected for the first time clearly by a federal court. And it was this case of Emerson versus the United States which ultimately, over time, gave rise to the litigations and the theories that ultimately allowed us to have the victories we found and saw in Heller, McDonald, Caetano, and yes, now just most recently, Nysurfer versus Bruin. So why am I telling you this story? In the Antonyuk case in the Northern District of New York last week, again, our side won basically on every argument associated with the Second Amendment. The conclusion being that the Second Amendment was violated repeatedly by New York with their new gun control laws. That was huge and very good news. But the case was dismissed because the plaintiffs allegedly lacked standing and therefore the court had no authority to oversee that case. He had no jurisdiction. Now, what happens on appeal, if that appeal is taken, I assume it will be, may be much different because I think the district court judge in that case probably got standing wrong and we'll see what happens. But I don't want you to be upset or depressed because these Second Amendment cases sometimes take time and there's fits and starts that ultimately give rise, in my opinion, ultimately expanding the right to keep and bear arms, which I think will continue. And I want to talk about this 2001 case in Emerson versus the United States because that's exactly what happened there. Now, in that case, you had a plaintiff by the name of Joe Emerson. He had recently gone through a divorce with his wife. In the context of that divorce, he had a hearing about the terms of the divorce settlement. Now, it looks to be, based on this record, and this is probably a bad judgment on Joe Emerson's part, but he apparently represented himself at the trial, and in the context of that, failed to properly address or did not adequately address really certain testimony associated with whether or not he had abused or had misbehaved vis-a-vis his soon-to-be then ex-wife. And as a result of that, a permanent injunction or permanent restraining order was entered in that case. And I'll put the case down below so you can check out the detailed facts. But it was entered in that case saying that he was not allowed to deal with the wife going forward. There was a restraining order, things like this. Now, that should not have mattered, except why it really mattered, because under federal law, 18 U.S.C. 922G, even then, if you had a restraining order against you, that permanently banned you from having firearms. So the reason why this is important is because after the divorce, Joe Emerson went out and apparently procured a pistol or a firearm, and this came to the attention of the authorities that then indicted him and charged him with a crime under 18 U.S.C. 922 as a prohibited person, saying, hey, you have a permanent restraining order, you're not allowed to ever have a gun again, and now that you have a gun, we're charging you with a crime. So Joe Emerson asserted and argued in court that the law, the federal 18 U.S.C. 922 that prohibited him from having a gun, especially on just a permanent injunction associated with a divorce, that can't be the case, he said, under the Second Amendment, which gives me an individual right to keep and bear arms. Now, this case was he actually won at the district court level, the trial court, but then an appeal was taken to the Fifth Circuit Court of Appeals, which is the major federal court of appeals in the area of Texas, Louisiana, and the like. This is a big case. It was argued, and the Fifth Circuit Court of Appeals, and this is why you see the analogy to the Antioch case, in that decision, the Fifth Circuit said, number one, the Second Amendment protects an individual right to keep and bear arms. Anyone that says just otherwise is simply not right. These collective right theories by the left in America, these arguments that it only gives you a right to be in the militia, that you only have a right to bear arms in a militia, whatever that is simply absurd. That's not how we interpret the Second Amendment. The Fifth Circuit Court of Appeals says you have an individual right to keep and bear arms in the United States under the Second Amendment, period, full stop. That's what the Fifth Circuit Court of Appeals said. That sounds great, right? The Second Amendment won. Yes. But what happened as they applied the facts to Joe Emerson? In that case, they said that, yeah, we agree the Second Amendment protects the individual right to keep and bear arms, but you, Joe Emerson, are a prohibited person under 18 U.S.C. 922. There's nothing wrong with that statute. So therefore, with respect to you and your specific case, you lose that case because on the facts, you are not allowed to have a gun. So the point being just, in the Emerson case, even though the Second Amendment movement won a huge victory in that 2001 decision by the Fifth Circuit Court of Appeals, the individual plaintiff there, Joe Emerson, lost his case. Now here, when it comes to the lawsuit brought by Gun Owners of America and Ivan Anton Young, again, I think they did a great job. With that said, though, they individually lost the case in the Northern District of New York, but the rest of the case really is going to serve, as my view, as a powerful precedent in support of the Second Amendment right to keep and bear arms. And we'll see how that case continues to play out. But even though the case was lost, I think it's ultimately going to be viewed through the sands of time as a big victory for the Second Amendment. You mark my words and see how this plays out. So again, to wrap up, the Emerson case 2001 was 7 years before the U.S. Supreme Court decided Heller versus the District of Columbia, saying that we had an individual right to keep and bear arms, but the Emerson case was a critical first step in that process that ultimately gave rise to the Heller case, then the McDonald case 2 years later, then the Cantano case in 2016, and now the Bruin case. And sometimes the gears or the wheels of justice turn slowly. I don't deny that. I don't think they're actually going to turn that slowly here with the Second Amendment. I think there's going to be a lot of favorable rulings really fast. There already have been. And I think the Second Amendment courts, the courts that support the Second Amendment, the courts that apply the Second Amendment are going to really start applying it robustly. I think we've already seen that out there in Colorado and in Texas and even in New York to some degree. But again, let's see this all play out. And I think it's all going to work out well for the right to keep and bear arms. But again, only time will tell. Okay, I hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.